You are driving home. The red and blue lights flash behind you. Your heart rate spikes. You pull over. The officer approaches. License, registration, insurance, routine. Then the question changes. Do you mind if I take a look at your phone? It feels casual, almost harmless. You hesitate for half a second. You think, I've got nothing to hide. You unlock it. In that moment, you may have just waived one of the strongest privacy protections in modern constitutional law, and most people do it without realizing it. Today, I'm going to break down 5 critical mistakes people make during traffic stops when it comes to their phones, and the exact phrases that protect you. Stay through mistake number 4, because that's where most lawful protections collapse. Not because of police misconduct, but because of your timing. I've spent years analyzing constitutional case law, reviewing body camera footage, studying suppression hearings, and dissecting Supreme Court rulings that define the limits of police authority. The law around cell phone searches is not intuitive. It has evolved rapidly in the last decade, and most officers and most citizens operate in a gray zone shaped by timing, consent, probable cause, and documentation. This is not about confrontation. This is about understanding the rules. Because when it comes to your phone, the Supreme Court has made something very clear. Your digital life is not the same as a wallet or a glove compartment, but those protections only work if you understand them. This is educational content only. It is not legal advice. Laws vary by state and facts matter. If you face a specific legal situation, consult a licensed attorney in your jurisdiction. Now, let's break this down. Mistake. 1 thinking it's just a quick look. It's A. The real-world scenario. The officer says, mind if I just check something real quick on your phone? It sounds limited, small, harmless. You think, sure, why not? B. The mistake. You assume a quick look means a narrow search. Legally, it does not. C. Controlling case, Riley v. California, 2014. In Riley v. California, 2014, unanimous 9-0 decision. The Supreme Court held that police generally must obtain a warrant before searching a cell phone seized incident to arrest. Chief Justice Roberts wrote that modern cell phones contain the privacies of life. This was a landmark decision. D. The legal principle. A phone is not a container. It is a digital archive of your life. Police cannot search it without a warrant, your voluntary consent, or a recognized exception, like exigent circumstances. E. How the mistake plays out. Officer, just unlocking it so I can verify something. Won't take long. You. Yeah, that's fine. You unlock it. The scope is now defined by consent, not by your expectations. F. The exact phrase to say, I do not consent to any searches of my phone. G. Why? This phrase works. Consent is one of the strongest exceptions to the Fourth Amendment. If you give it voluntarily, courts almost always uphold the search. If you clearly refuse, officers must rely on another legal basis, like a warrant. Clear refusal preserves your rights for later review. H. Nuance. Refusing consent does not create probable cause. However, if independent probable cause exists, for example, evidence of a crime in plain view, officers may seize the phone and seek a warrant. But seizure is not the same as search. That distinction matters. Bottom line. Never assume quick means limited. Consent opens the door, and once it's open, it is very difficult to close. Mistake number 2, unlocking the phone, just to show cooperation. A. The scenario. The officer doesn't even ask to search. Instead, they say, can you unlock it for me? You want to appear cooperative, so you comply. B. The mistake. You think unlocking is neutral. It is not. Unlocking can itself be testimonial. C. Controlling case. Carpenter v. United States, 2018. In Carpenter v. United States, 2018, 5-4 decision, the court ruled that accessing historical cell site location data requires a warrant. The broader theme, digital data carries heightened privacy expectations. While Carpenter dealt with location data, the court reinforced that digital information receives stronger Fourth Amendment protection. D. The legal principle. There are 2 constitutional protections at play. Fourth Amendment, search and seizure. Fifth Amendment, self-incrimination. Unlocking a phone with a passcode may be considered testimonial, Biometric unlocking, fingerprint or facial recognition, has been treated differently in some jurisdictions. This area remains legally contested. E. How it plays out. Officer, just unlock it so I can see your messages. U. Okay. Now the phone is accessible. The barrier protecting years of information is gone. F. The exact phrase to say, I do not consent to unlocking my phone. G. Why it works. It clearly denies consent. It also avoids making a testimonial act that could later be argued as compelled cooperation. H. Nuance. Some courts have compelled biometric unlocking but not passcodes. State laws vary. Judges differ. But voluntary unlocking removes the issue entirely, in the prosecution's favor. Timing matters. Once unlocked, you cannot retroactively withdraw that access. I. Bottom line. Unlocking is not neutral, it is access, and access changes everything. Mistake 3. Believing an arrest automatically means a phone search. A. The scenario. You're arrested for a traffic-related offense. The officer takes your phone. You assume they can now search it because you're under arrest. B. The mistake, confusing seizure with search. C. Controlling case. Riley v. California, 2014. Again, in Riley, the court held that police may seize a phone during arrest to prevent destruction of evidence, but they may not search its contents without a warrant. D. The legal principle search incident to arrest allows officers to search your person and immediate surroundings for weapons or evidence. But digital data is different. The court recognized that phones contain vast quantities of information unrelated to the arrest. Therefore, warrant required. E-dialogue, U. So you can't search that without a warrant, right? Officer, we'll see. If you have already consented, that protection may be gone. F. The exact phrase to say, I do not consent to any search. I want to speak with an attorney. G. Why it works. It preserves both Fourth and Fifth Amendment protections. It clearly ends voluntary dialogue. It signals invocation of counsel. H. Nuance exigent circumstances can override the warrant requirement. Examples: imminent threat, immediate risk of evidence destruction, but those exceptions are narrow, and courts scrutinize them closely. I. Bottom line, arrest does not equal automatic digital access. A warrant is the rule. Exceptions are the exception. Mistake. 4. Talking too much during the stop. This is where most people lose protection. A. The scenario. You're nervous. You start explaining. You say things like, I was just texting earlier. My friend sent me something. There's nothing bad in there. You are trying to appear transparent. B. The mistake. You are creating probable cause through your own words. C. Legal authority. Probable cause. Doctrine. Probable cause arises when facts and circumstances would lead a reasonable officer to believe evidence of a crime exists. Your statements are facts. They go into the report. They appear on body cam. They are replayed in court. D. The principle. Small talk is not neutral. Statements can justify seizure. Warrant application. Expanded detention timing is everything. What you say before invoking your rights can shape the entire case. E. How it plays out. Officer, have you been using your phone tonight? You. Yeah, just texting while stopped at a light. That single sentence may justify further investigation. F. The exact phrase to say, I prefer to remain silent. G. Why it works. Clear invocation of your right to silence limits voluntary statements. Courts treat explicit invocation differently from passive silence. You must state it. H. Nuance. You must provide identifying information required by law, but beyond that, silence is protection. Tone matters. Calm, respectful, clear. I. Bottom line. Your words can become probable cause. Silence is not hostility. It is strategy. Stay through this mistake in your mind. Rehearse it, because this is where most rights disappear, through conversation. Mistake 5. Believing, if I refuse, it looks guilty. A. The scenario. You fear that refusing consent will make you look suspicious, so you comply. B. The mistake. Confusing legal rights with social pressure. C. Legal authority. The Supreme Court has repeatedly held that refusal to consent cannot itself establish probable cause. Exercising constitutional rights cannot be treated as evidence of guilt. D. The principle. You're allowed to say no. The Constitution assumes you might. E. Dialogue. Officer. Why won't you let me see it? U. I respect what you're doing, but I do not consent to any searches. F. The exact phrase. I respect your job, but I do not consent to any searches. G. Why it works. It is calm, non-confrontational, clear, it removes ambiguity, it documents refusal on body cam. H. Nuance. Officers may still detain briefly within lawful limits, seek a warrant, seize the phone if probable cause exists, but refusal itself does not create probable cause. I. Bottom line. Politeness and firmness can coexist. Refusal is not aggression, it is preservation. Core Principles section. All of these mistakes connect to one unifying principle. Your rights are strongest before you speak. The Constitution protects you most effectively when you do not consent, you do not unlock, you do not volunteer, you clearly invoke. Timing is everything. Once consent is given, courts rarely undo it. Once statements are made, they enter the record. Once access is granted, privacy is gone. Digital privacy is powerful, but fragile. Here are the phrases. Memorize them. Practice them calmly. I do not consent to any searches. I do not consent to unlocking my phone. I prefer to remain silent. I want to speak with an attorney. I respect your job, but I do not consent to any searches. Say them slowly. Say them calmly. Tone matters. Volume matters. Body language matters. You are not arguing. You are preserving. Understanding your constitutional protections is not about avoiding responsibility. It is about understanding the structure of lawful authority. If this breakdown helped you understand your rights during a traffic stop, make sure to like this video and subscribe for more high-stakes legal analysis. In the next episode, we're breaking down a question that surprises even law students. Can police order you out of your car, even if you did nothing wrong? Let me know in the comments what state you're watching from. Laws vary, and your location shapes how these principles apply. Stay informed, stay calm, and understand the law before you need it.